Hello and welcome to Legal Briefs Crypto Geeky Edition, and today I attended the SEC versus Ripple hearing made very easy by a cool new invention called the telephone. And wow, this was a very special hearing because there were two bombshells, and so on a scale of 1 to 10, this hearing was an 11 for Ripple.
Up, all the way up, all the way up. You're on 10 on your guitar. Where can you go from there? Where?
I don't know.
Nowhere, exactly. What we do is if we need that extra push over the cliff, you know what we do?
Put it up to 11.
11, exactly.
So I got on the hearing and I was drafting a motion on my computer while I was listening because these motions and these hearings are pretty mundane, and honestly I wasn't expecting this to be any different. But around the 15-minute mark I stopped working on my brief because I realized the judge was letting this go further afield than normal. Actually, I got so interested in the hearing that I never did finish the brief I was working on. Remind me to call my malpractice insurance on Monday. Because honestly I was blown away in a kind of legal nerd way by what I was hearing, and I'm going to tell you exactly why. But first, real quick, remember not to take what I say as legal advice. I'm the lawyer who didn't finish his client's pleading today, so if you need a good lawyer, call this guy. He can get anyone off, or so I've heard. Put his name in the comments for free YouTube juice, please. Okay, so before we get to the hearing, let me bring you up to speed. We have 4 pending main motions in this case. One is to compel discovery of documents by the SEC relating to Brad and Chris's financial information. Now that is the hearing that took place today. We also have the SEC's motion to strike Ripple's fair notice defense. We have the individual defendants Brad and Chris's motion to dismiss the lawsuit against them altogether. And then we have Ripple's motion to compel discovery from the SEC about why it took 7 years to sue Ripple and some other juicy tidbits. The motions to strike the affirmative defenses and the motion to dismiss the lawsuit will both be ruled on by Judge Torres, and here's the scheduling order. Let's take a look. So you can see first the Brad and Chris's motions to dismiss will be briefed by June 4, and the SEC's motions to strike Ripple's defenses will be briefed by May 27. Now I'm not super happy with this schedule because I was hoping to see a much quicker time frame. With this time frame, we probably won't have rulings on these motions until mid-June at earliest. Also, I would be remiss if I didn't mention today that Attorney John Deaton refiled his letter to get his motion to intervene in the lawsuit heard by the court. You may remember that the court initially denied this motion, but as he promised and as I said a couple days ago, he was going to refile his letter, and he did that today. Remember, I am never wrong. And here is his letter. Here, Attorney Deaton in the second paragraph is asking the court to be allowed to intervene in the SEC versus Ripple case on behalf of over 10,000 XRP holders. 10,000. Now last time, just a week ago, that was number was only about 6,000. And I think I went over that in my last video, why this intervention in the lawsuit is so important. So keep an eye on this motion. But let's go to the main event. The SEC wanted to get records of the individual defendants Brad and Chris's financial information. They wanted very detailed financial information about bank accounts, checking accounts, everything. At this point, Brad and Chris had already given the SEC the trading financial documents. In other words, they had given the SEC documents showing that on such and such a date, Brad Garlinghouse sold, for example, 1 million XRP for $300,000. So the SEC has all those trading documents already. So please understand that I've played this game for 20 years, and let me tell you exactly why the SEC wants all this detailed financial information. There's only 2 reasons to try to get this information. One, sometimes I will ask for this type of information because I want to catch the defendant in some kind of discrepancy. So the trading financial records show, for example, that Brad made $300,000 on December 1st, but his bank account only shows a deposit of $295,000. So it leads it to a cross-examination of, hey, Brad, what happened to the $5,000? And sometimes you can make the witness kind of look bad like that. And the second reason, and this is what the motion is all about, the SEC is trying to get these detailed records in order to make rich guys look bad. Now it's a common technique, and what they want to do is they want to get a record that Brad Garlinghouse spent $10,000 on a new toilet bowl for his house and $25,000 for a birthday party for his kid. They want to get that in front of the jury, and that's all this is. They want to make them look filthy rich and hopefully leave a bad taste in the judge or jury's mouth. And don't blame the lawyers too much, it's a dirty business we work in. In any case, the first thing I'll tell you is that Judge Netburn saw this motion for what it really was, and she asked a very pointed question. And I think she said something like, quote, "Do you have some evidence that the trading financial records are incomplete or somehow fraudulent?" And I don't think the SEC really had a good response to that question. So after the hearing, I thought that the judge is not going to give the SEC most of what it wants. I changed my mind on that point after hearing the hearing. The second thing I have to tell you is that Brad Garlinghouse's lawyer, Matthew Solomon, is an absolute beast. He looks younger than I thought and fresh. Usually litigators look tired and haggard, kind of like me. And look where attorney Solomon worked until 2016. He was the SEC's chief litigation attorney for 3 years. Interesting. Anyway, I was super impressed by him. He was amazing, and I'll leave it at that before things get kind of weird. But none of that is the big news from the hearing, not even close. First off, there was the bombshell from the judge just about 15 minutes in, where the judge interrupted Mr. Solomon to say this, quote, "My understanding about XRP is not only does it have a currency value, but it has a utility, and that utility distinguishes it from Bitcoin and Ether." Then attorney Solomon had to, of course, disagree with the judge and say, no, XRP is similar to Ethereum. Now, the comment itself shows that the judge has done some research and is trying to understand, but it's not quite there yet because, as we know, Ether has utility, a lot of utility, and has been given a pass already by the SEC. So the comment in a way didn't make much sense. But even if the logic is faulty, the statement is premised on two humongous things. One, that XRP has a currency value, and two, that XRP has utility. First, no matter what the SEC might try and argue, a currency and a security are by definition inopposite. A currency can be used to procure things of value. A security is an ownership interest in a common enterprise. They are two different things. The example you see in a lot of the case law is the laundromat example. If you buy tokens for a laundromat that hasn't been built yet, you've bought a security. But once the laundromat is built, you now have a currency because you can buy something of value with the tokens. And that's the second thing that the judge disclosed, is that she has bought into the argument that XRP has utility, that at least at the present time, that XRP can be used to do things, and that is exactly what Ripple wants the court to be thinking. When she first was talking and said currency and utility, I thought she was Chris Larson's attorney or something. She sounded like she was arguing the case for them. Boom, wow, I mean, that's the point at which I stopped working on my client's work and started listening, and I'm glad I did because there was one more big point that was more subtle. But I just want to flesh one thing out first about the judge's statement. Now, this hearing was with the magistrate judge. Her name is Judge Netburn, and it is true that she isn't the main judge on the case. But the first thing you have to understand is that in federal court, Judge Netburn and Judge Torres, they're kind of like a team, and they work along with law clerks. They talk about cases, they roundtable them, they go out to lunch, they talk about them over lunch. So when Judge Netburn says XRP is a currency with utility, and she says it as a factual statement, you better believe Judge Torres is very likely saying the same thing, or at least knows that Netburn feels that way. And the other thing to know is what the role of the magistrate judge is in the court. Let's take a look at a guide to the federal magistrate judge system for more information. What does a magistrate judge do? They settle discovery disputes, they conduct mediations, and they make recommendations regarding summary judgment. Yes, Judge Netburn will be involved at the two most important junctures of this case. She will be mediating the case, and she will be involved in discussions with Judge Torres as to who should win the case. Now, if I'm Ripple, I'm feeling pretty good that my mediator and consulting summary judgment judge just said on the record what I essentially argued in my pleadings. And when I say I'm feeling pretty good, I mean, like, is this really happening? Pretty good. But there was one more thing that was huge in today's hearing that you had to listen very carefully or you could miss, and it might be super important for everyone, so listen to this. About halfway through the hearing, the judge skeptically made a remark to the SEC attorney that based upon his theory, everyone who sold XRP, including you and me, are selling illegal securities, and she was skeptical about it when she asked the question. And this is what the SEC lawyer said on the record. He said, no, under Section 4, only Ripple and affiliates of Ripple can have sold XRP illegally. Listen to that again. The SEC said that only Ripple and employees of Ripple can illegally sell XRP. Now, why is that super important? That means that the exchanges that delisted XRP 2 months ago were not and would not be violating securities laws if they relisted XRP for sale and began to sell it again. And I think I saw recently that one exchange recently relisted, and so I wonder if there are perhaps a slew of non-action letter requests coming or already received by the SEC, and if so, I wonder if we will see XRP for sale in the US of A once again. I hope so. Anyway, it's extremely late here as I shoot this and I have to sleep, but thanks for watching, and remember, pay attention to the small and mundane things in life. Sometimes that's where you find the greatest insight.